Hi everyone, Dave Sugden of Evidence at Trial. Let's talk about depositions. Depositions can be challenging. Sometimes witnesses can be intentionally difficult.
So you're just a lawyer, you're an ambulance chasing lawyer, so don't start with me, I got all day.
Sometimes lawyers try to get in the way of the examination.
You're not allowed to make speaking objections, you're not allowed to give
Don't lecture
opinions.
me, puppy. Don't lecture me. I was doing this when you were still chasing cheerleaders. Don't you even think about lecturing me about depositions.
And sometimes witnesses simply have a hard time remembering anything.
Guess what? I don't recall.
Today we're going to talk about something hugely important in California depositions, and that is the lack of foundation objection. Now we're told about the types of objections that are permitted during depositions as opposed to trial, and we're told objection is permitted as to the form of any question or answer at a deposition, and to avoid waiver, such objection must be made on the record at the deposition. Fair enough, but then this practice guide tells us that inexperienced counsel often raise objections on such grounds as relevance, hearsay, or lack of foundation. These do not go to the form of the question, and such objections are improper, and that persistence in making such improper objections may constitute discovery abuse. So let's talk about foundation. Is that an improper objection to make at a deposition? The rule for objections for depositions is found at California Code of Civil Procedure, section 2025.460, subdivision B. And it provides that errors and irregularities of any kind occurring at the oral examination that might be cured if promptly presented are waived, unless a specific objection to them is timely made during the deposition. So we need to object to things that might be cured if promptly presented, and if not promptly presented, the objection's waived? Isn't that exactly what a lack of foundation objection is? Suppose we have a car accident case, and a witness is asked, question, Mr. Witness, are you aware that there was an automobile collision on January 1st, 2017 at the intersection of Main and Broadway? Answer, yes. Question, what color was the traffic light on Broadway at the time of the collision? Answer, red. Let's next suppose that Mr. Witness is not available at trial, and the examining attorney wishes to introduce this testimony at trial. You object to the testimony on the basis that the testimony lacks foundation. Although Mr. Witness testified that the light was red, there's no testimony about how Mr. Witness knew the light was red. In other words, personal knowledge of the testimony was not established, and thus no foundation for the testimony. You therefore object to this portion of the deposition being read or played at trial. Your opposing counsel argues that the objection was waived because had such an objection been made, the examining attorney could have cured the issue right away. This remains a murky issue in California because so many authorities presume that a lack of foundation objection is improper. In fact, some practice guides caution lawyers to be aware of foundation in the absence of an objection, warning attorneys not to get trapped by opposing counsel's not objecting to your questions. If you try to use a deposition as evidence at trial, you're bound to run into an objection at the time of trial that there was no foundation for the deponent's testimony, and the testimony is therefore incompetent. Accordingly, we are told if you intend to use deposition testimony at trial, and you usually do, phrase your questions to avoid all substantive objections, hearsay, no foundation, conclusions, etc. Otherwise, you may find you've conducted an expensive discovery procedure that does little good in the long run. In federal court, however, there's an important exception to the general rule of form-only objections in federal cases. As one treatise explains, however, and this is an important however, even other objections must be made at the deposition if the evidentiary defect presented by the question can be cured at the deposition. Too many lawyers believe that they need to object only as to the form of a question, and that all objections regarding the question's substance are preserved. As a defender, you may need to object to the competency of a witness, to questions that seek inadmissible opinion or conclusion, for example, when a lay witness is asked for a legal conclusion, and to questions that lack foundation or are speculative. Specifically, Federal Rule of Civil Procedure 32D3A provides that an objection to a deponent's competence or to the competence, relevance, or materiality of the testimony is not waived by a failure to make the objection before or during the deposition unless the ground for it might have been corrected at that time. As a result, several district court judges have articulated that lack of foundation is a per se proper objection. According to one judge, in my view, objecting to form is like objecting to improper. It does no more than vaguely suggest the objector's taking issue with the question. It is not itself a ground for objection, nor does it preserve any objection. Instead, form objections refer to a category of objections which includes objections to leading questions, lack of foundation, assuming facts not in evidence, mischaracterization or misleading questions, non-responsive answer, lack of personal knowledge, testimony by counsel, speculation, asked and answered, argumentative questions, and witness answers that were beyond the scope of the question. So, for a belt and suspenders approach, make the foundation objection when defending depositions, and when taking depositions, don't assume that a lack of a foundation objection means the issue is waived. Make sure you get the substantive testimony you need and lay the necessary foundation for it. Folks, I hope this was helpful. If it was, please like, subscribe, hit the notification button. If you want a topic covered, leave a comment. If you want to do a deep dive on these evidentiary issues, check out our online course page at evidenceattrial.com. Thanks for watching.